IVM.
Welcome to Police Chowki, a special limited series on your favorite public policy podcast, All Things Policy. This series will take you behind the khaki uniform, beyond the flashing red beacon, and into the heart of the functioning of the Indian police force. We cast a critical eye on the role and function of the police in the Indian democracy, from the silent persistence of paperwork and meticulous investigation to risky counterterrorism efforts and policing in conflict zones. We explore the need for police reform and accountability in the system. Each episode brings you a comprehensive exploration of a unique facet of policing, illuminated by the insights of a former IPS officer who has lived the life behind the badge. So join us every Monday morning as we take you into the complex world of Police Chowki.
Hello and welcome to another episode of Police Chowki. Today we are going to be talking about the Bharatiya Nagarik Suraksha Sanhita 2023, which is going to replace the Criminal Procedure Code of India. In the last episode, we had talked about the Bharatiya Nyaya Sanhita, which is going to replace IPC. IPC is still the substantive criminal law of the country, while the procedure as to how a criminal investigation is supposed to be done, how police officer is supposed to exercise his powers of arrest and seizure, how a trial is conducted by the court, what is the kind of punishment that can be given, and the different stages of criminal prosecution is essentially governed by the CRPC or the procedural code. Now, the Nagarik Suraksha Sanhita is the new bill proposed by the government, which is going to overhaul and replace the CRPC. And procedural law is very important as far as criminal justice system is concerned, because this is essentially the battleground between individual rights and the power of the state, as well as the system which governs the delivery of justice in our society. So to talk about the Nagarik Suraksha Sanhita today, I have with me our guest on the show, Mr. Javeed Ahmad. He's a former IPS officer and DGP of Uttar Pradesh. He has vast experience in criminal trials, so I'm hoping that his experience will help us make better sense of some of the provisions of the Suraksha Sanhita. So welcome to the show, Mr. Ahmed.
Yeah, good afternoon, Sri. Nice to be back.
Right. So there are many provisions which have been changed in the CRPC, although substantially a lot of it has been retained from the older code. But we'll look at some of these changes because they are very significant. So this episode is going to be more about, us discussing this different provisions of CRPC which are being amended by the Nagarik Suraksha Sanhita and trying to draw the implications of such changes, what kind of repercussions it will have on the rights of individuals, on speedy trial, on the powers of the police and so on, right? And the first provision which we thought we'll discuss is essentially one about custody. So what happens when an accused is arrested? So initially, as per the current CRPC, the idea is, ironically, people are not safe in police custody in the country, in the sense that there have been many, many instances of police torture, police custodial deaths, and so on, which meant that the CRPC tried to limit the time that an accused is permitted to be within the custody of the police after he has been arrested for any offense. Now, the current law is, out of a total period of 60 days, which can be extended to 90 days of custody, only 15 days is allowed to be in police custody. Rest of it is in judicial custody. But now the Nagarik Suraksha Sanhita makes a change. It says that, out of these 60 days or 90 days, it need not be just the first 15 days, which is in police custody, but this might be extended. In fact, out of the total 60 days, in the first 40 days, any number of days could be in the police custody as long as the total is 15. So now this has some serious ramifications. So I thought let's begin with this. So Mr. Ahmed, I wanted to know your thoughts on this proposed change and, why it matters to the rights of accused, and why do you think this sort of change might, destabilize the current justice system that we have?
Yes, before I answer that question, let me reiterate the point that you made in your opening comments, that the CRPC as it now is and the Nyaya Sanhita as it's proposed, this is the code or the procedure laid down through which the due process of law, which is defined in the Constitution of India, it actually plays out. This code is very important because it defines how the state can proceed against an individual who is accused of any particular crime. It gives certain powers to the state, obviously, but it also gives certain powers and rights to the individual, which are very essential for him so that he can prove his innocence in the court, and that the process of trial is conducted in a fair manner. At every stage, sufficient time, sufficient opportunity is given to the accused person so that the state does not have a monopoly or a one-sided run in the trial. So that's about the CRPC and why it is important. Now, coming to this issue of custody, 14 days custody or police custody as it is called. The position now is that the 14 days police custody of an accused can be given within the first 14 days of the arrest of the person. To give an example, if a person has been arrested on the 1st of September, then in the next 14 days, the police can make a request for police custody, and this period is utilized by the police for interrogation or whatever it is. Now, the new provision is that these 14 days need not be the first 14 days of arrest as it is presently, but they can be stretched over the overall number of days of judicial custody, which is 60 days or 90 days, depending upon the nature of the crime. Why is this important, and why has this been brought about? There are instances where, for example, the CBI, where I worked for more than a dozen years, gets the investigation of a case much after the incident has happened. At times, it is even 1 year or even 3 years after the incident. The accused may have been arrested initially, spent 60 days or 90 days in the court. During that period, the police may have taken custody or not taken custody, and now he's on bail. So effectively, what that means is that the new agency, especially the central investigative agencies, do not have any time with him for a one-to-one. This used to create a lot of problems for the investigative agencies because they did not have the opportunity to talk to the person on a one-to-one basis, because the case came to them much later, even 6 months, 8 months, 1 year, or whatever number of months later. Now, having said that, I would say that there is a case for extending the 14-day period into over the 60 or the 90 days, but this should not be a blanket permission given to the police. It should be only in specified cases which justify such an exception, rather than give a blanket permission or authority or opportunity. I would rather go for that. Now, why? We all know that the experience of the last 75 years show that police custody often results in third-degree torture or extrajudicial methods of extracting information. And the whole exercise of reforming the police has to be linked to not just structural changes, which we normally keep hearing about, but also changes in the procedure and the processes that the police follow, so that they become more humane, more scientific, and more aligned to the constitution of this country. By allowing this or inserting this provision, I have a feeling that this process of humanizing the police, making them more accountable and making them more constitutionally aligned, may suffer a setback.
Well, yeah, I do take your point, Mr. Ahmed, that in many cases where the case has been handed over to a central investigative agency, this particular custody period might have been exhausted by the police, and they might require custodial interrogation, for which an enabling provision like this can be made. But again, the fact remains that there is a cap of 15 days in total. So if the police has already exhausted that 15 days, then I think the central agency might not be able to avail of this facility. But anyway, moving on now, let's look at another aspect of CRPC, which is very crucial to all of us, which is the registration of FIR, or the first information report, right? So essentially, if there is any information regarding a cognizable case which has come to the notice of the police, or any informant has passed it on to the police, it is the duty of the police to register a FIR and begin investigation. And this was, for once and all, it was settled in a case called Lalita Kumari of the Supreme Court, which is a landmark case in this regard, which said it is the duty of the police to register a FIR. However, this new bill sort of makes a small tweak to the provision of registration of FIR, and it says that for offences which entail 3 to 7 years of punishment, the police may proceed with investigation when there exists a prima facie case. And in cases where the police want to confirm that there is a prima facie case, they may conduct a preliminary inquiry before proceeding. Now, a lot of critics have argued that this is the exact kind of ambiguity which the Supreme Court put an end to, because we do not want the police dilly-dallying on registration of FIR. But somehow this idea of preliminary inquiry has now been brought back into the law, where the police may delay registration of an FIR for an offence, right? That's the first part. And the second important issue regarding FIR is that, there was a provision in the CRPC which said that police, whenever they choose not to investigate a case for whatever reason, they need to inform the informant. But this was seen as essential by the courts also, because the informant is a key stakeholder in the whole criminal trial and investigation process, right? And this has even led to like judicial remedies called protest petition, which meant in case the police proceeds to not investigate a case, they can go to the court. But now this crucial clause which said that the police have to inform the informant that they are deciding not to pursue a case has been omitted, right? So these are the two changes which have been brought in the provision regarding FIR, and I want to know your thoughts on these changes.
We'll talk about the first issue first, about the registration of the FIR after an inquiry or a preliminary inquiry in some cases. Let me tell you that in the CBI, for example, there are many cases or many complaints that are received where first a preliminary inquiry is conducted to ascertain the prima facie sustainability of an FIR. This is done not to this is done so as to ensure that frivolous FIRs, especially against public servants or people of repute and people of standing in society, are not registered. This is a provision that has been in the CBI manual for 45-50 years, and it has withstood the scrutiny of the Supreme Court also. Now, in the case of the police station, the local thana, as you very rightly said, Lalita Kumari judgment came and it was said that FIR should be registered right away. To start with, let me say that I am very much in favor of free registration of FIR. And the registration of the FIR gives some kind of hope and assurance to the victim or the complainant that the judicial process or the legal process will start. Unfortunately, what happens in reality is that the registration of the FIR itself becomes a tool for harassment, especially if the FIR is being registered against persons who are named. What I want to say is that there can be two categories of FIRs. One, that, for example, that I had gone to the Brigade Road Market, my car, a Maruti, Contessa or whatever, number ABCD, red color, etc., was parked, and now I find that it is stolen. It is gone. It is stolen. Please register a case. This is a case where you are not naming anyone. You are not accusing anyone of having done this. There can be another situation where you say that I came home and I found that the lock is broken and some people have broken in and stolen my stuff, and I think that ABC have done it. Now, when you say that ABC have done it, you are accusing someone of it. In case that accusation were to be found totally incorrect, then what is the remedy available to A, B, and C? That is a question that often comes up in real life policing, because that ABC are called to this police station, they are harassed, they have to go through all kinds of mental and physical harassment and trauma. Unfortunately, in the law of perjury in India is very weak. I can make an accusation and nothing comes out of it, and I am totally safe. I am not made liable. So in such cases, there can be an argument that a preliminary inquiry of the nature that you are talking about requires to be conducted. This is a slippery ground, I must confess. It is a slippery ground because such cases of misuse of the process of FIR will be not many, maybe 5-10%. But in that process, the possibility of the local police dithering or not registering an FIR, that there can be a situation like that. So I can see why this section has been brought, the provision has been brought. I can also see the potential mischief that this section or this provision can cause to the common man.
Right. And on the aspect of, malicious prosecution that you mentioned, I think that was another opportunity lost, because I don't think any of these changes in the new bill take this offense seriously and, enhance the quantity of punishment or fines that
Correct.
can be
Correct.
imposed.
Correct.
So that is definitely a ground where we need subsequent, we need serious reform, both lying under oath in case of perjury, as well as, filing frivolous cases just to target and harass people. And this is, unfortunately, the case is that, the state has resorted to these kind of tactics as well. So there needs to be stronger safeguards which will protect individuals from this kind of harassment by filing all kinds of cases against them. But another aspect where, this is a mixed bag as far as the new Nagarik Suraksha Sanhita is concerned. This is regarding detention of under trials. Right now, India has huge problem of overcrowding of prisons. Nearly 2/3 of prisoners are under trials, which means, they have been arrested and the trials are progressing, but they have not been convicted of any offense. But to whatever reasons that they can't, either the bail has been denied or they can't make bail, they continue to remain in prisons. To solve this, one of the steps which was taken was introduction of a new provision after the Supreme Court ordered, which said that, if any person has undergone half the maximum imprisonment for which he has been accused of, he will be set free from the jail and his detention will not be continued. Right now, the code has done, the new Sanhita has done some changes to this. The positive change is that for first time offenders, this one half punishment has been reduced to 1/3 of the maximum imprisonment. So, for example, if someone is accused of an offense which has 3 years punishment and this person has spent 1 year already in jail without any conviction, then he'll have to be set free on bail. But now there is another change which is not so welcome in my opinion, which is that earlier it said that if an accused is has been jailed for an offense which is punishable with death, then this, release from detention will not apply. Now, this has been extended to include the offenses punishable by life imprisonment. And here's the catch: persons against whom proceedings are pending in more than one offense, which means that essentially if anyone is in prison being accused of more than one offense and half the punishment has half the time of imprisonment has already passed with respect to one offense, but for the others it's pending, then this person can't be set forth. Right, which means this is tricky because in situations in how the law has been practiced in India, we see that a lot of people are slapped with offenses one after the other. New kinds of offenses are registered post the registration of the first one. So this might just mean that, persons will continue to be incarcerated without conviction for longer periods of time. So given these changes, Mr. Ahmed, I want to know from you whether they are desirable, since you know very well the state of our police and prisons and under trials in our country.
Yeah, so the problem of overcrowding of prisons is a very, very serious problem. And to the extent that a provision has now been made that those who are first time offenders and have completed 1/3 of their potential sentence, they can be let out on bail. This is a welcome provision. And I see a lot of people who have been charged for very, very petty offenses getting some relief from this provision, and I, to that extent, it is a welcome provision. As far as the other provision is concerned of someone not being able to get advantage of it if he has more than one case, I would like to differentiate here. I would have preferred if the provision had differentiated between some kind of heinous crime or, petty crimes. For example, a lot of people are arrested for possession of small amounts of narcotic drugs, or for ticketless traveling, or for such other minor offenses. These people need to, even though they may have been arrested and they are charged on more than one matter, in more than one case, they I think are essentially petty criminals who need to be given the advantage of the first provision that we talked about, especially in light of the fact that prisons are highly overcrowded and the trial itself takes many years. It is not only time consuming, but it is also very expensive. and the legal aid provisions on the ground are rather bleak. So that is how I see it.
Right. But talking of lengthy trials, so this Sanhita actually has two major fundamental reforms, and much of it is in the positive direction, which I want to bring out. The first is, using electronic communication methods for most of the processes under the law, and the second being prescribing a very specific timelines for various procedures to be completed, right? And I'll go over both of these briefly to give better context for all our listeners. The first thing that I spoke about using electronic methods. Now, the bill provides that all trials, inquiries, proceedings, recording of evidence, examination of parties, issuance, service, execution of summons and warrants, and all other processes under the Sanhita will be done electronically. And it also says that, electronic communication devices which contain digital evidence, etc., can be produced for trials. Of course, some of these amendments have been made in CRPC and all, but this sort of clarifies the position on this. Now, the second is it prescribes timelines for various procedures. For example, it requires medical practitioners who examine rape victims to submit their reports within 7 days. Police investigations for trials of cognizable offences need to be completed within 90 days. After the trial is over, the judge has to pronounce judgment within 30 days of completion of arguments, which can be extended up to 60 in some cases. After 90 days, the police is bound to inform the progress of the investigation to victims. The framing of charges by the court has to be done within 60 days from the first hearing on such charges. And as far as adjournments are concerned, of course, we all know Tariq pe Tariq and all the problems associated with the system. The the new code provides that only 2 adjournments can be allowed after hearing the other party and after recording reasons in writing. So, of course, these are massive overhauls. As far as electronic communication is concerned, I think that's a welcome development. But again, there'll be problems as to how exactly the delivery needs to be done. I mean, I'm not sure everybody has an email ID or functional email ID. So, what will be the recognized way of doing this? Of course, it's easier in cases of, say, corporations or companies and so on, but for individuals it's a difficult task. And I think one of the consequences of this will be that, a lot of police manpower will be freed up because they were engaged in the delivery of these court summons, right? The other aspect, fixing these timelines, I don't know, because this kind of a step had been taken under many laws previously, but just by fixing timelines, we've not been able to deliver speedy justice. So I want to know your thoughts on both these reforms brought in by the Sanhita.
First off, my first reaction would be that these reforms are very, very welcome. I think they were much overdue, and by incorporating them into the statute, the legislature would have done each one of the individuals who have to face the criminal trial a lot of good service. As far as the electronic service of summons and other processes is concerned, yes, you are absolutely right. A lot of manpower would be saved because physical service of summons obviously requires a lot of time of people having to travel from one end of the country to another and all that. So by making it possible electronically, a lot of time will be saved. It will be more efficient, and the courts will now be in a position to fix shorter dates because the service of summons would have happened within 1 or 2 days rather than 20 and 30 days, as the case is now in many matters. So there may be initial hiccups, but I'm sure with the passage of time, the system will develop the infrastructure for for implementing this. And I think this is a very, very welcome step. As far as the trials are concerned, about completing the trial within a specified period or the number of adjournments being limited to 2, and the judges having to pronounce judgments within 30 days of conclusion of the trial. Once again, these are all very desirable and very long awaited provisions that have been incorporated, and each one of these has the potential to improve the justice delivery system. And with cooperation of the advocates of the legal community, I am sure that the courts will be better placed to finalize trials and deliver justice within a shorter period than what is presently the case. To give you an example, if the number of adjournments is actually limited to two, it can be an absolute game changer. I don't know whether the adjournment limited to two applies only to the prosecution, or does it apply only to the defense? Can the prosecution take two adjournments, and then the defense can take two more adjournments, and the court can take two more adjournments because it is busy with some other matter? I don't know. These are issues that will get resolved as time goes by, and probably the respective high courts will frame rules in this regard. And as I said, the cooperation of the bar is very important. I don't know how they will react to it, because there is an impression that extending the trial period is one of the methods of income for the bar. That's a allegation that is made from time to time. So the cooperation of the bar is very important. I hope they will cooperate. But overall, I think all these provisions, in effect, will improve the justice delivery system.
Stay tuned to All Things Policy. We'll be right back after a short commercial break.
Right, just on the adjournment bits, yeah, the 2 day limit applies to parties requesting for adjournment. So I assume both the prosecution and the defense will get two chances. But this does not really curtail the power of the courts to grant adjournments for whatever reasons, right? And this could be anything from, delay, just exceeding to request.
The courts are overworked. There may be an instance where the court, both the parties are ready, but the court is busy because it has many, many more cases on its table than it can handle in a particular day. So there may be issues, but as I said, these are all welcome steps. It will take time for each of these steps to, take shape and get into a practical mode. But a very good beginning, I would say.
Right. And of course, one of the main reasons why adjournments are also granted is because of non-appearance of witnesses. But I think this new bill tries to put a stop to that by saying prosecution evidence can actually be closed if witnesses are not turning up after taking all reasonable measures. So let's see how this plays out. But the other thing on the timelines, of course, I'm with you on the whole electronic methods or using them in the entire criminal justice process. But on timeline specifically, I have my reservations because there is no penalty or any consequence of breaching these timelines, right? Not like the case will get dismissed or the accused gets away or there is some, inquiry against the police officer or against the judge or any of them, which essentially means despite fixing all these timelines, the system might continue the way it has been doing. Although we hope not, although we hope there are changes, but without, concrete sort of like consequences for breaching these timelines, I don't see them being very useful. But having said that, let's move on a little bit and talk about the investigation aspects of it. Of course, I think we sort of did it in reverse. We spoke about trial before we did investigation, but for what it's worth, let's talk about investigation a little bit because there are some very significant reforms as far as investigation is concerned, right? So the first one is now the new bill mandates forensic investigations for all offenses which are punishable with at least 7 years of imprisonment, which means most of your murder, rape, and so on will be covered in this. On all such cases, forensic experts will have to mandatorily visit crime scenes to collect evidence and record the entire process on a mobile phone or any such other device. But if a state does not have a forensic facility, it can utilize such facility from another states and so on. But although this is a welcome development, and we have had an episode on forensic science earlier and we spoke in detail about this might still take a long time to be implemented because there are many challenges starting from resourcing to state capacity and budget provisioning and capacity training and so on. So what challenges do you see in the implementation of this forensic investigation mandate?
Each of the problems or the challenges that you talked about are real challenges of state capacity, of budgets, of availability of trained manpower. Each of these are, and more than anything else, change in attitude and training amongst the field level officers. Each of these is a problem in itself, and the whole issue needs to be tackled from that perspective. But my understanding is that slowly most state police forces across the country have developed some amount of forensic capability, and with the push that comes from this legal provision, the non-availability of funds would be mitigated to a large extent, because if there's a legal requirement, the legislature will be bound to make available resources in terms of money and other infrastructure. So I think these things will take time for 100% compliance, but I am sure that in the next 5 to 7 years, we will be in a much better position as far as scientific investigation is concerned than we are now. So, with that positive, expectation, I would welcome these provisions.
Right. But there is another provision on investigation which I believe is a little concerning as far as privacy of individuals is concerned. Earlier, in order to collect any fingerprint or voice sample or handwriting samples, etc., a person had to be arrested in connection with an offense, which means there has to be some reasonable suspicion that this person has been involved in the offense. But now this provision has been sort of diluted. The new bill says that, the police may, with the permission of the magistrate, ask any person, regardless of their background or involvement in offense or whatever, or a history of arrest, to give specimens or samples such as fingerprint, voice sample, or handwriting samples, right? This is worrisome because we have seen a lot of media reports where police are just going around catching anybody on the street corner, asking them to show their mobile phones or taking their photos. In Hyderabad, there have been instances where police were actually asked to do this in order to train their facial recognition software better, and so on. And India, of course, there is very limited awareness among people on, the dangers of parting with your personal information in such a way to the state. Plus, there is limited protection as far as data protection and all is concerned, because even the new data protection law gives blanket exemptions for criminal investigation and trials and so on. So, what do you think of this provision? Was this necessary for any reason, or do you think this is an overreach that has to be remedied?
My assessment, Sri, is that any power that is given to the police without any accountability attached to it has the potential of misuse, as it is with any authority. The police have, in the last 75 years, not done enough for the common man in India to believe that the authority and the power that they have will be used in a responsible manner. So now to allow the police to take samples of anyone who's suspected of any crime or something like that, something as broad as that, I think it is definitely an intrusion into the privacy of the individual. And this whole provision has very rightly been criticized in certain quarters, and I stand with those who feel that this provision needs to be watered down, so that only where it is required for the interest of justice and for the furtherance of the investigation, that the police should have this authority, and that too after they have convinced a magistrate that such an action is required for the furtherance of the investigation. A blanket permission given to the police in such matters will definitely raise the hackles of everyone who believes in the privacy of the individual, and that no one should be made to to give evidence against himself, including by making available information available on his mobile phone or on his laptop, unless there are grounds for such an action by the police.
Right. Another aspect of investigation is, of course, protection of witnesses. We have spoken about this previously on this podcast and on the status of the witness protection schemes in the country, which is quite poor, to be honest. The idea is essentially to ensure that people are more forthcoming about information regarding crimes. They're more forthcoming about presenting their views before court so that the trial goes through and the accused is convicted. Many jurisdictions offer witness protection schemes. Many have very advanced protection to witnesses, including relocation and new identity and so on. But at the bare minimum, there needs to be some amount of support from victimization, some amount of support from threats to their life and property and family members and so on. Right. Now there is a section in the new Nagarik Sanhita which says every state government shall prepare and notify a witness protection scheme with the view to ensuring the protection of the witnesses. Now this is welcome. The inclusion of it in the code is welcome. There have been a lot of judgments by the courts which have supported this. I think many states have notified such schemes. But apart from this, the code is silent on, what all should the scheme cover, what kind of protection needs to be granted, what are the minimum standards that every such scheme should provide for. Do you think this is something which needs to be included? Do you think this Sanhita sort of misses out on the chance of explaining the critical elements of a witness protection scheme?
I think it's an opportunity missed as far as witness protection is concerned. The Honorable Supreme Court has laid down certain parameters for witness protection, and that could have been a good starting point for some provisions being made in the statute. To leave it to the states to do it, I think is kind of passing the buck. And I hope that at the stage of consultation, this gap is taken care of. It is addressed, because witness protection becomes very important in sensational cases or high profile cases where the accused persons are influential, or have resources and have the ability to silence a witness either physically or through other resources. There could be various ways of doing it, and there are the expectation that a law abiding citizen will depose before the court, which is one of the basic presumptions of the Indian Evidence Act. While it is a very noble presumption, the fact of the matter is that most people would not risk their life and limb and that of their kith and kin and their financial stability and resources for deposing in a matter if the state were not to have their back, so to say. So I think there's still hope that during the consultation process, this lacuna, this gap would be addressed, and certain liabilities would be fixed on the state so that important witnesses can get advantage of this provision or this system. The fact is also that a lot of agencies, law enforcement agencies, do this work in an informal way by using resources from the secret fund or some other resources, or some they're putting strings here and there. So it's not that it does not happen, but when there is a legal and a statutory backing, obviously it becomes much easier even for the law enforcement agencies to further it by giving good effective protection to an important witness.
Right. And it's to the credit of the police and investigative agencies that this is being carried out in an informal way. But I still believe that it is the state's responsibility to sort of safeguard witnesses so that the ends of justice can be achieved in the society. But before we close, this was one interesting aspect that I wanted to bring out, which is regarding the use of handcuffs, right? So, we are very, very used to seeing handcuffs being used in popular media, in detective shows, in police shows, and movies, and so on. But I was also actually surprised that there is this Supreme Court decision from the 1980s which barred Indian police from using handcuffs, and I want to know the extent of the truth behind this from you, or having had the experience of probably handcuffing people. But other than that, now the new provision in the Sanhita wants to bring back the use of handcuffs for serious offences. It says that, given the nature and gravity of the offence, police officer may use handcuffs while effecting the arrest of a person who is a habitual offender or who has committed organized crime, terrorist acts, drug crimes, illegal possession of arms and ammunition, etc., etc. And this has also been, it's a fair amount of debate has erupted over this aspect as well. So I want to know from you two things. One, what is the situation of handcuffs as far as Indian police arresting accused is concerned, and do you think this is a welcome change?
Yes, since the mid 80s, I don't remember the exact year, but yes, around that time, the Supreme Court mandated that no one would be handcuffed. So no one is handcuffed for the last 30, 40 years, whatever it is. And obviously, it leads to a lot of problems because there have been many instances of people, breaking free and running away, especially during transportation from place A to place B on trains or buses or such other public transports. In certain cases, handcuffing maybe is required. As a police officer, my DNA does not allow me to oppose this provision because hazardous criminals or professional criminals, they need to be restrained, and we have to recognize that there are a large number of people who are outside, who are out in the open, who are ready to help them escape, and handcuffing them is a very balanced and very rightful tool for ensuring that they don't run away from the law.
Right. And what do you think was the thinking behind this prohibition of handcuffs?
I think the background to that was that somewhere in Gujarat or somewhere, the police had arrested a judicial officer and they had handcuffed him. It raised a lot of furor and all that. I may be wrong, but I think that is the story. And in response to that, the Supreme Court passed this order. And that's how it has been for the last 30, 40 years.
Right. Thank you so much, Mr. Ahmed, for joining me on this podcast on the new Bharatiya Nagarik Suraksha Sanhita. Of course, there are a lot of scope for improvements and, in fact, corrections also, because there are a lot of inadvertent errors which have crept into this bill right now, which is being examined by the Parliamentary Standing Committee. We do hope to see a final draft which, sort of makes corrections regarding a lot of these issues and maybe even sort of drops some of these more undesirable provisions, so to say. While we wait for it, we also plan to do one more episode on the evidence law in the coming weeks. So stay tuned for that. Thank you so much, Mr. Ahmed. See you next week.
Thank you. Thank you, Shri.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.